want to tell you. I forgot how to share the damn screen. Hey, is it working now? Honey, is it? Mute yourself. I can't hear you. Can you see the slideshow?
I can see the.
Can you mute your thing, honey?
It is muted, Mark.
Okay, is it?
Do it as a slideshow.
Okay, can you see the slideshow now?
Yes, I can. But it's not a slideshow. It's just slides.
I know, but I'm going to share. Well, how does this look? Hold on a second. Is that better?
No, it's the same.
Shit. Okay.
It should be a slideshow.
I don't know how to start a slideshow.
It should be
I don't know if it tells you if anybody's here yet or not. I think 3 people are in, so we're a little early. I can't hear you.
I'm ready. I'm just,
Listen, if you go to slideshow, you press play from start.
Okay, I just need to know if it's filling the screen when I hit play from start. So you need to look.
Yeah, it is.
No, it's on my screen, but is it on yours?
Yeah, let me look.
your call has been forwarded to voice.
Fuck's sake, I'll just call Evan.
Hello?
Hey, I got a question. Can you see the full screen with the slideshow?
I see the full screen.
Well, does it show the slideshow?
It does, but you can also see on the side the slides.
Okay, I don't know how to get this to to work. All right, technology is always a little bit of fun.
Yep.
Okay. All right. Well, this is going to be this should be interesting. We'll see if the other 148 people who've signed up show up.
Well, I'm here.
Okay.
So,
All right, brother. Thank
there
you.
go, man.
All right. Bye.
See you perfectly on LinkedIn.
Hello, everyone. Welcome to LinkedIn Live. I'm going to wait a few minutes to give some people to join us, get some people to join us, and then we'll start. Thank you for being patient with me. Who's going to start? Well, hi, everybody. Thank you very much for joining me. I appreciate you being a little bit patient. Technology is not one of my strong suits. I'm just checking to make sure you guys can all hear me. So my wife, who is present with us, has assured me that you can in fact hear me. So thank you very much for joining me. My name is Mark Astor, and together with my wife, we are the co-founders of a law firm. We're based here in Boca Raton, Florida. We also have an office in Boston, Massachusetts. And while I've been practicing 30 years. My wife has been practicing for the last 32 years. For the last 10 years, we've done one thing and one thing only, and that is to save families whose loved ones have substance use, mental health disorders, and failed attempts at recovery. And we take calls typically from mums and dads, not always mums and dads, but that's our typical client who have an adult child, somewhere between the ages of 18 to 25, who has a long history of substance use, mental health disorders, in and out of treatment centers, trips to the emergency room for overdoses. And this thing has been going on for years and years and years. And the families come to us basically because we are the last port of call. And so every day, my wife and I and the rest of my team take calls from just about every part of the country. Even though we're based here in Florida, we are taking calls from as far west as Hawaii. We've had some cases out of the country. We are working with a family right now who is based in Italy, and they come to us because they don't know where else to turn. They've tried everything, and so we're the last port of call. So this is my opportunity to share what we do, what gets us out of bed every single day, and it's our mission. And so thank you very much for joining me. I'm probably going to talk for the next 30 to 40 minutes. If you have any questions, please let me know. At the end of the video, I'm going to give you my my email address, and I'd be more than happy to share this slideshow with you. It would be a pleasure to do that. So let me start the slideshow and tell you a little bit about how all of this works and how we work with families. Let's make sure you can see it. Okay, my wife says you can see it. So this is good. So this is the title of the presentation. So there are two parts to our law firm. So there is me with my beautiful wife. We've been actually only been married since January, although we've been together for years and years and years. I refer to her as the guardian, the guru of guardianship, because she knows more about guardianship than frankly any other lawyer I've ever met, and routinely does trainings for other lawyers to teach them about using guardianship. So this half of our practice, which is the mental health addiction law firm, is really focused on putting people into treatment. People who won't go to treatment, people who won't stay long enough in treatment, people who have been in and out of treatment, but have never really experienced the true miracle of recovery. The other half of the firm is BakerActAttorneys.com. And the Baker Act is a statute which I'm going to talk about in a little bit. It's unique to Florida in terms of its abuse. But it is a statute that allows the state of Florida to take custody of somebody when there's a mental illness apparent and the person presents as an immediate danger to themselves. And we really started doing a lot of Baker Act work when COVID came along, which was one of two things that really changed the dynamics of our practice. And I also had my own family member Baker Act, and that was a big influence on me. So these are the two halves of the practice. A little bit about me. I've been practicing since 1994. I was an intern in the Palm Beach County State Attorney's Office in 1993. And after spending 6 months there trying lots of cases, it was the only job I wanted. And I was there until 1999. One of the things I noticed very early on in my legal career as a young prosecutor is that we were seeing this. I was seeing the same people over and over again. And I said, this is something not right here. Why am I seeing the same faces over and over again? And why are the alleged offenses more serious? Why is the punishment more serious? And what I realized pretty quickly was that the criminal justice system was full of people who had substance use and mental health disorders and weren't getting the help that they needed. And, obviously things have changed dramatically since then. We now have, we have drug courts and mental health courts and veterans courts and things of that nature. But back then, we didn't have any of those things. And the mandate in Florida back then and even today is to punish first and rehabilitate second. Punish first, rehabilitate second. Well, if you've got somebody who has a disease and you just keep punishing them, their disease gets untreated, and at some point they end up getting locked up. And from experience, having had several clients that were in both the state and federal penitentiaries, it's not a place you want to be. It's certainly not a place you get well. So what do we do? Tonight I'm going to really talk to you about the legal component, but there are really three components to what we do. And these three things together are what enable us to get great results. There's the legal, which we'll talk about in a second. There's what I call law enforcement. So I have a retired cop on staff. He has a team of investigators who help us to find people, because we get a lot of calls for missing people out on the streets. And if I can get a judge to give me a pickup order, I will send John, who is my lead guy, out there with or without one of his investigators. We'll find the person, and they will contact law enforcement and say, hey, we have this person here. We have a pickup order. Please, please, please send a couple of deputies down here so we can get this person picked up and taken to a place of safety. And at some point, shortly thereafter, we'll go back to court and have a full-blown evidentiary hearing. But right now, time is of the essence. Someone's in danger, and we need to get them, and we need to get them quick. The third component is what I call the clinical. And this really has been just an absolute game changer, especially in the last 5 years when we had COVID and we had the legalization of marijuana down here. So I have a couple of clinicians who are a very, very important part of our team. I believe Mr. Jersha, Evan Jersha, who's really key and critical to some of the work that we do, is here with us. He's just amazing. But having that resource for families is a game changer, because we need to be able to find the right facility for the person. And if they have health insurance, and mom and dad have been paying premiums all these years, well, they want to get the benefits that they're certainly entitled to under that insurance policy. So these three things work really, really well together. So these are the three, what I call behavioral health laws. There's the Marchman Act, there's guardianship, and there is the Baker Act. And we're going to talk about these three statutes over the next 25 to 30 minutes. I'm also going to talk to you about the changes, some of the changes that have kicked in for 2024. July the 1st, we had all these new laws come on the book, and there were some changes to the Marchman Act and the Baker Act. As I mentioned, two really important factors that have caused significant change in the way that we handle things. There was the COVID-19 pandemic. And the reason that was a game changer was because we had folks calling us who could not get in to see their clinicians. They couldn't get in to see their primary care doctor. And they were calling 211. They were calling 911. They were showing up at hospital emergency rooms because they didn't know where to go for help. And the families were calling us and saying, help us to get our loved one some help. And we were seeing folks that never had a substance use or mental health issue starting to have those issues. We saw people that had been in recovery for years and years and years suddenly relapsing. And it was just an absolute game changer. The other thing it did is that we went from 10 years ago dealing with primary substance use cases to now dealing with primary mental health cases. I mean, I don't think we have had in the last 3 or 4 years somebody who only has a substance use disorder. There is always mental health disorders associated with that, and there may or may not be some kind of substance use. If there is substance use, more often than not, it's marijuana. And, as a child of the 80s growing up in the United Kingdom, I had a number of friends who smoked marijuana. And, with the exception of one or two, I mean, they all went on to have, fruitful, productive lives. But the marijuana of today is not the marijuana of the 80s. And it is very powerful. It is very dangerous. And a good friend of mine who works in the treatment industry said to me when it was first legalized that it was going to be a serious problem here in Florida, that it was a gateway drug. And candidly, I didn't really take that seriously because, well, I'd seen it in the 80s and didn't think it was a problem. Well, he was right. And we have seen a lot of cases where there is marijuana involved. It tends to cause paranoia, delusions. If there's any kind of mental health issue going on, this is like pouring gasoline on a fire. So when you have those two factors combined, it has really, really changed the dynamics of what we do. So having John, my investigator, with his team, and having clinicians like Evan Gershow helping us with the cases that we have has, just been amazing, and we're very grateful for those folks. So what is the Marchman Act? Let's talk about that, because when I first started doing this work 10 years ago, I used to get calls from people saying we never heard of the Marchman Act, and yet it's been on the books for years and years and years. It's changed over the years. It just changed again in 2024, but it is a statute that allows, or even should I say, empowers a family to put their loved one into treatment for periods of up to 90 days where there's a primary substance use disorder. Now, there very well could be a co-occurring mental health disorder, but there has to be primary substance use. If there's no primary substance use, we cannot file a Marchman Act. Now, as lawyers, in addition to the fact, we have to know the substance use is primary, we have to be able to prove it. We're governed by rules of evidence when we're in the courtroom, rules of procedure, rules of substantive law. And so part and parcel of when we, quote, triage a case, when we talk to a family for the first time, is finding out if we can actually prove the case. Because we're not going to take a case that we can't prove, that we can't win, we can't get the right result for the client. That's just not the way we handle cases. And maybe it's not a Marchman Act case, but maybe it's a guardianship. And we'll talk a little bit about that in a second. So that is sort of what the Marchman Act is designed for. Primary substance use, it can be filed if we're dealing with an adult, which we typically are. Pretty much any one person with direct personal knowledge can be the petitioner. I have a case right now where I actually have an interventionist, and he's the petitioner. He has the most knowledge about the individual we're dealing with. He's been, working with him for the last 5 years. If it's a minor, then it has to be a parent or a legal guardian as a general rule. We don't get a lot of minors. I don't think in recent memory we've had any minors that we've had to file a Marchman Act against, although I can tell you I've represented a number of minors when it comes to the Baker Act. And again, I'm going to talk to you about that in a little bit, because that's become one of my favorite topics to talk about because of how easily it's abused here in Florida and how often it's abused. So this is sort of the basic criteria for a Marchman Act. And we're really dealing with somebody who, a bit like a Baker Act, where they're presenting as a danger to themselves because they've lost the power of self-control, because they're being driven by primary substance use. And they simply cannot appreciate their need for services, right? They're in denial. And a lot of the time when we're dealing with a family, whether it's primary substance use, primary mental illness, the family will say to us, I've talked to my loved one, my son, my daughter, whoever it happens to be, and they don't think they have a problem. In fact, they think that we're the problem and we should go to treatment. Yeah, I mean, that's the nature of what you're dealing with. If they realize that there was something wrong with them, then perhaps they might be willing to take some action to remedy the situation. But it's part of the disease, and I tell families, look, don't try to rationalize this. It just is. It's a disease, and it's got to be treated, or it will get worse. And eventually, horrible things happen. So that is sort of the basic outline of the statutory criteria. And I put up here at the top here, good faith belief, because there are 2 steps to this, and we're going to talk about that in a second in terms of the burden of proof. Remember, I told you, as lawyers, we have to worry about, the law and our burdens of proof when we are going into court, because these are court filings. Now, and you see here, I've got 2023, and I'm going to explain to you why. There's 2 steps. There's 2 steps to the Marchman Act. Step 1 is a period of assessment and stabilization and detox if it's needed. The second component is treatment. That's when we're going to send somebody to go to treatment. So part and parcel of the reason that we need an assessment is, number 1, we want somebody, a clinician, somebody who's considered under the statute as a qualified professional. Somebody like Mr. Gershow, a licensed mental health counselor, a licensed clinical social worker, a psychiatrist, a psychologist, a certified addictions professional, somebody who can come into court and give the court an expert opinion and say, yes, Your Honor, this person meets criteria, this is why, and this is our recommendation for treatment. If there's no assessment done, then no treatment can be ordered. And that, if we're going to a contested hearing, meaning the person is going to challenge this, the respondent is going to challenge this, which they have a right to do, then we need that person to come in and testify. So what's really, I guess the word is neat, what's interesting, what's cool about the period of assessment is that we can do it on an emergency basis. And I'm going to talk about that in a second. But part one is the petition, is the period of assessment. Part two is the period of treatment. Let me just see what we have here. Okay. All right, so I'm going to talk to you a little bit about the changes. So it used to be, you see there's two steps to this. In 2023, it used to be we have to file two separate petitions. I got to file a petition for assessment, and I got to file a petition for treatment services. Now, the involuntary assessment can be done. You see here, emergency. What does that mean? It means we don't have time to file a petition, have a hearing, get a counsel appointed for this person, and decide if they're worthy of saving. Your Honor, this is such an emergency. I want you to read my petition. I want you to grant it. I want you to issue an order mandating this person be assessed. And I want you to authorize the police to go and get them and pick them up and take them to a place of safety. Now, as I said at the beginning, one of the critical parts of what we do is John, my law enforcement guy, because if this person isn't where they're supposed to be, if they're out in the streets, if they're even missing, then we got to go find them. And it's not because the police don't care. You know, we have a lot of friends in law enforcement, and we're very blessed for that. It's not that they don't care. They simply don't have the bandwidth nor the resources to go to be looking for someone. If they're not at the location where we tell them they're going to be, they're done. They're going to leave. And sometimes we don't have an exact location. And the courts have been very gracious with us over the years because they know that we'll go find them. And so if we don't have a specific address, you know, John's going to go find him. He's going to contact his friends in law enforcement, and we are going to find that person. So we'd file part one, get them picked up. You'll see here it says it's typically good for 5 days. Again, that has now changed under the 2024 statutory change. And again, I'll talk about that in a second. You'll also see here, it talks about protective custody. So there's actually three, and I don't want to confuse you, there's actually three ways to initiate a Marchman Act, a bit like a Baker Act. It can be done by filing a petition with the court. It can be initiated by law enforcement, which is the protective custody, and it can be initiated on an emergency basis. An emergency room doctor initiates it. As a general rule, it's only going to get initiated only one of those three ways. That's by the filing of a petition. There is one county in Florida that actually will Marchman Act somebody that comes in for some kind of substance use related issue, and that's up in Alachua County, actually at UOF, and I've had a number of cases up there. They will Marchman Act somebody, but they're the only county I've come across that will do it. It typically takes the filing of a petition for assessment and stabilization. Now, if for some reason the judge doesn't think it's an emergency, and I will tell you that we have had every once in a while we get a judge who doesn't believe there's an emergency, and you know, you can never take the human factor out of our court system, and you know, sometimes we don't agree, but listen, we're officers of the court. We have to respect the order that is issued by the judge, and if we don't like it, we ask for, you know, some type of, you know, a review, some type of, you know, we'll file something new, something additional to give the court some additional facts. But if the court doesn't think it's an emergency, it's going to set a hearing on that petition for assessment and stabilization. But let's say we get our assessment done. Then we need to get a petition for treatment services filed because we need a hearing. Because it's at that hearing that we're going to be able to ask the court, can you send this person to treatment for up to 90 days, which is the statutory maximum under the Marchman Act. Now, in 2023 and for the years before that, it was a two-step process. Not anymore. It's a one-step process. What that means is we have to request everything: the emergency petition, the pickup order, the order for assessment, the treatment services hearing in one document. And if we don't ask for everything in one document, it's waived. Goodbye. So if for some reason we were to forget to ask for that assessment order and we don't get an assessment, then, well, we're going to be out of luck because the court can't order treatment without an assessment. Now, as I mentioned in part, as you saw on the past slide, it used to be that the assessment order was good for 5 days. You could extend that window past 5 days because Marchmont Court, in just about every county I've ever been in, is once a week. Well, if it's every 7 days and the court order is only good for 5 days, what happens to that person? I mean, they could, in theory, go out and use again. They could disappear. The old statute said if we file a petition for treatment services within the 5-day window, the facility, the receiving facility, could hold them pending further order of the court. That has now changed. The assessment period right now in 2024, you'll see here, is 72 hours. And there's a big unless. Unless the respondent shows signs of withdrawal or a need to be either detoxified or treated for a medical condition, which shall extend the amount of time the respondent, the person on the receiving end of this, may be held for observation until the issue is resolved. But it should say no later, so I apologize for the typo. No later than the scheduled hearing date, absent a court-approved extension. So basically, if these elements aren't there, excuse me, told you technology wasn't one of my strong points. If these elements aren't there, 72 hours, the person's got to get released. Unless, you'll see here, number 5, the period extends, the 72 hours ends on a weekend or a holiday. And that's very much in line with the Baker Act, which also has a 72-hour hold. I'm going to be candid with you. I'm not all that excited about this 72-hour hold under the Marchmont Act. I think it could be a problem. But it is what it is, and we, as officers of the court, we have to operate within the law, and we figure out ways to make sure people stay safe. And that is sort of the changes. It's not all the changes, but the big changes for us in 2024. So let's talk about part 2, which is the treatment. This is the treatment part of things. And remember, I said it's still one filing, but there's still two steps: assessment, treatment. Well, now we're talking about potentially taking someone's liberty away. We're going to send them to treatment for the next 90 days. Well, even though this is a civil proceeding, some of the constitutional protections that we would associate with a criminal case, they still apply. The right to a hearing, due process, the right to counsel, and if you cannot afford a lawyer, one will be appointed for you. The right to make the petitioner prove their case. Now, at this stage of the proceeding, the burden of proof is clear and convincing evidence. You remember the assessment period is just reasonable basis, which is a little bit lower. Not quite as high as a criminal case beyond a reasonable doubt, which I dealt with as my time as a prosecutor and defense lawyer, but still a pretty high burden, right? And if we go to the hearing and the respondent doesn't want to go to treatment, then we have to prove our case. Plain and simple. And that might mean I have to put parents on to testify against adult child. Not a fun thing to do. Very upsetting for the parents. But at the end of the day, we're trying to save somebody who cannot make the decision to save themselves. Okay. Now, if the court decides that we've met our burden of proof, which, most of the time we would like to think that we do, or we won't file the case, they're going to be sent to treatment for a period of up to, not 4, but up to 90 days. What does that mean? It means that the treatment facility has some discretion, some wiggle room. First of all, they could, in theory, discharge the person before 90 days, although on the cases that we see, that typically does not happen. They also get to decide what level of care the person is maintained in. Is it residential, PHP, IOP? And unfortunately, sometimes that, what I would consider a clinical decision, is going to be made by an insurance company who's going to tell the parents they're only going to pay for 21 to 30 days of residential, and after that, they got to step down. So sometimes that's what we have to deal with. But the idea is to get them into treatment for 90 days. Now, I will tell you, in our office, most of our Marchmont Act cases go beyond 90 days. We normally, we'll file a petition for extension, and we run them 180 days. And the reason we like to do that is because in our world, in the cases that we deal with, we want to try and keep somebody in recovery for about a year. We just know from experience that after a year, they develop the skill set to maintain lifelong recovery. So if they can do 6 months in treatment, whether, a combination of residential, PHP, IOP, and then they can step down and start sober living and walking the 12 steps and getting a sponsor, right? All of those things, going to AA, all of those things, then they got a shot. Then they got a chance to maintain recovery. And while all of this is going on, one of the things we try to do to get our families to is to participate in some type of family program. The really good facilities will have these family programs because, look, we all know, it's a family disease. This is like a metastasizing cancer that is slowly destroying the family unit. It's why nobody in the house can get a good night's sleep. It's why mom and dad are fighting, right? I mean, all of these things. And so we got to get them help. We got to give them time to heal too, because they need it. And if we can get the family to heal, if we can get their loved one to heal, then we're going to get a great outcome. And it's a beautiful thing to see. And that's why, my wife and I get out of bed every morning and try to help as many people as we can, along with the amazing professionals that we work with. So let's talk a little bit about guardianship. As I told you, my wife is the guru of guardianship. She's truly brilliant. She practiced in Massachusetts for many years before she came down to Florida. Lucky me. As I said, I'm a child of the 80s, and for those that are similarly aged, you probably recognize what this is. It's the DeLorean from Back to the Future. And I have this up here because I refer to guardianship as a time machine, right? Because when somebody becomes 18, here in Florida, they're considered an adult. That means they get to make their own decisions, right? They want to get married, they can get married. Want to buy a house, they can buy a house, right? If they have substance use and mental illness and they want to continue to do that, well, somebody has to step in and try and make the decision for them, right? So if they're over 18, our typical window is 18 to 25, maybe a little bit older, but not much. We need to turn the clock back. We need to jump into our guardianship time machine and go back to a time when they were not 18 years of age, when they couldn't make decisions for themselves, and give somebody the right to make that decision for them. Because without that right to make decisions for them, one of which is going to be the decision to go into treatment, well then, who's going to make it for them? I mean, is the state going to make it? Possibly. And I'll talk to you about how that can happen too. But what we like about guardianship, and I'm going to get into all of the rights that can be, taken away, is it's very what I call broad in application, right? There are 12 rights you can potentially take away from somebody. And I'll go over those in a second. So it's really broad. The Marchman Act is very narrow. And what I mean by that is that when I say it's narrow, I mean it's simply a court order that says, Mark, you will go into treatment for the next 90 days. And if you don't follow what's recommended by the facility, if you become non-compliant or you walk out against medical advice, well, then you're going to be seeing a judge. And because it's civil in nature, you could get held in contempt and potentially go to jail. Now, I'll tell you, in all the years that we've been doing this, I think only one time have I seen somebody decide that jail was a better option than a treatment center. But it can happen, and it's that accountability that helps to maintain and keep somebody in treatment. But sometimes that's not enough. We might need the ability to restrict travel. We had a family that we represented. In fact, Dad was a lawyer, and we told him, you need guardianship here because, your daughter, he had an adult daughter in her early 30s, is a flight risk. And he didn't want to listen to us. Well, we put her in a treatment center literally in the middle of nowhere. It was just a treatment center surrounded by sugarcane fields. The magistrate handling the case allowed his daughter to have her phone for 24 hours over our objection, and she called in the middle of the night. She called an Uber and jumped on a plane. Took a flight down to Mexico. Well, obviously, when she got there and realized, she might have made a big mistake, we had to send John down there to get her and bring her back safely, which we did. But had we had guardianship, one of the things that we could have suspended was her right to travel, and she wouldn't have been able to jump on that plane. So, really a powerful tool. And sometimes we'll do a Marchman Act and a guardianship together. Why? Why would we do that? Well, because it gives us maximum control. And remember, I told you, Marchman Act can be initiated on an emergency ex parte basis. No hearing. Now, again, depending on the county, because some counties are great at this and other counties are a complete disaster. They simply don't know what they're doing. You can't get the assessment. It's a mess. And there are some counties we simply won't file a Marchman Act in. We'll file a guardianship instead. But if we can get that ex parte order, for instance, Palm Beach County, fantastic place to file. Broward, pretty good. Hillsborough, Orange County, all pretty good counties to file in. But if I file in Palm Beach County at 9, good chance I'll have an order by 12, and by 3, John's picked that person up, got him in safe. You can't do that with a guardianship. Even if we file an emergency guardianship, and I'm going to talk to you about that in a second, still we need 24 to 72 hours to get into court. Well, in 72 hours, somebody may be gone, figuratively and literally. So we need a little help. But again, I got to have primary substance use under Marchman Act, or I'm not going to be able to plead my case and get a court order. Let's move on. Okay, let's talk about the difference between the emergency guardianship and the permanent guardianship. So a bit like Marchman Act, there is an emergency, portion to this. We refer to it as the ETG, emergency temporary guardianship, good for 90 days, a bit like a Marchman Act. You have that 90-day court order. And normally we can get into court, again, depending on the county, how busy the judges are, 24 to 72 hours. Okay, and it doesn't require an expert. The last one we did, I think I had the wife. She was petitioning for guardianship over her husband, who, by the way, was a lawyer. And we've put a lot of lawyers into treatment too, and represented a number of lawyers too. Unfortunately, our profession seems prone to some of these issues. In any event, we'll file an emergency temporary guardianship petition. We also have to file our permanent guardianship petition, and we file a petition for incapacity. So a lot of moving parts going on here. Now, let me talk to you briefly about the criteria, because obviously the criteria are key and critical, right? If you can't prove your case, judge throws you out of the courtroom. And here I've underlined it for you. The court must make a finding that there appears to be imminent danger that the physical or mental health or safety of the person will be seriously impaired, or that the person's property is in danger of being wasted, misappropriated, or lost unless immediate action is taken. So in the last case I told you about with the lawyer, he had a horrible substance use issue, significant mental illness. We filed the Marchman Act, a guardianship against him, and in the middle of all of this craziness, he got Baker Acted 4 times. So we were running backwards and forwards between 3 different courts. It was quite the scene. But the problem was that he clearly was unable to make decisions for himself. He clearly would not go into treatment. He would not stay in treatment. He was absolutely delusional about his situation. I'll leave it at that. They also had a business, and we were worried that the business would be affected, financially. Would some of the funds be taken or misappropriated? So we needed to get some control here. Remember, I told you guardianship is very broad, Marchman Act is very narrow, but Marchman Act is faster. Okay, and there was substance use here, so it was not a problem to prove it. Okay, here are the rights that can be taken away, and there's 12 of them. I'm not going to go over all of them, but the ones that are key and critical are the rights to travel. Right. Remember, I told you with that lawyer whose daughter we were dealing with, we would like to have been able to restrict her ability to travel. The big one: make medical or mental health decisions. Make the decision to put them into treatment. Really key and critical. Okay. We can also apply for benefits on their behalf. Right. If there's some kind of disability, we can, on behalf of the ward. If I'm the guardian, and God forbid my wife is to become the ward, probably going to be the other way around, where she's the guardian, I'm the ward, she can apply for benefits on my behalf because I no longer have the legal ability to do that. So she can do it for me. She can also manage my property, right? She can control my finances if we need to. And here's a biggie. She can get access to my medical records. So when I'm in treatment, she can find out what's going on. Because a lot of the time under Marchman Act, we put somebody to treatment and they don't want to sign a release of information. Remember, medical records are protected under both Florida and federal law. So having access to those things is really, really important. Okay, let me talk to you about the Baker Act, and then I'm going to talk to you about why you should even come to Florida for treatment. Like why are people in California calling us? Why are people in Hawaii or Italy or Panama? Why are they calling us? I mean, we're just a small law firm in Florida. And by the way, we're barred in Massachusetts too, but the bulk of our work is down here. Why are people coming to Florida? We're going to get to that, right? Marchman Act and guardianship are key parts of that. Also the fact that we have amazing treatment down here. Fortunately, we've really cleaned up the industry big time here, thanks to some federally funded task force that have arrested all the bad actors and shut down all the bad treatment centers. And now you're left with a very small core group. And for what it's worth, I can count on one hand who we will even work with. And I can tell you on one hand who we definitely won't work with. But there are some great treatments, great treatment down here. But one of the problems with Florida is this Baker Act. Okay. And I get, my wife is asking me how long. I will be done in about 15 minutes, 10 minutes. So the Baker Act is not, and I want to emphasize not. It is not a treatment statute, okay? And I get calls almost every day, 2-3 times a day. We want to put our loved one, we want to Baker Act our loved one. Why? I want to get them into treatment. Then don't Baker Act them. The Baker Act is a statute that allows the state of Florida, not you, not the parents, the state of Florida to take custody of somebody. When there's a mental illness, you see I have mental illness underlined here. When as a result of some type of mental illness, they present as an immediate danger to themselves. Okay. And the statute is very clear about what is mental illness, right? It's an impairment of the mental or emotional process that exercises conscious control of one's actions. What it does not include is someone with some type of developmental disability, autism, right? Intoxication, substance use, right? A TBI, traumatic brain injury. And I can't tell you how many times we've seen cases where somebody unfortunately had some type of mental developmental disability and got Baker Acted, or they were intoxicated. I see it all day long, and it's very, very sad. Here in Florida, there's two types of Baker Act. There's the involuntary, which most people will associate with a 72-hour detention. And remember, I told you one of the big changes to Marchman Act is we now have a 72-hour detention. And there's the voluntary. Well, why would somebody ever agree to be voluntary if the state of Florida is now becoming your de facto guardian and you become a ward of the state? Well, it happens because you got tricked, you got lied to, or you got coerced. That is typically how somebody gets voluntarily Baker Acted, I'm sorry to say. Now, during COVID, people were showing up at the hospital, or they were calling 211, or they were even showing up at the local Baker Act facility, and they say, listen, we can't get in to see our primary care clinician. We need help. Okay, well, would you like to be assessed? Yes, I want to be assessed. Sign here. What they just signed was a voluntary admission agreement. And the big difference between the involuntary and voluntary is that under voluntary, they can, in theory, keep you indefinitely without a court order. And if you tell them, listen, I want to leave, they don't have to let you go. Now, remember, you are in a lockdown, jail-like, secure facility. You're not going anywhere. Now, at the end, if it's an involuntary Baker Act, typically, which is initiated by law enforcement, not always, a bit like Marchman Act, can be initiated by law enforcement, qualified professional like an emergency room doctor. Somebody goes to the emergency room for some type of issue, an overdose, some type of suicide attempt. The emergency room doctor can initiate that 72-hour detention. And it can also be initiated by somebody going to the courthouse and filing a petition requesting a period of assessment. 9 times out of 10, those cases are filed by accident because somebody told them, oh, you want to get your loved one to treatment, go file a petition under the Baker Act. And then 72 hours goes by and they call us all upset. You know, the Baker Act facility hasn't called us. We can't get any information. Well, yeah, because now the state's taken custody of them. That's what the Baker Act is. We wanted them to get help. Then you shouldn't have filed the Baker Act. But people don't know, and they get bad advice. And that's where we come in. So you've got the involuntary and the voluntary. Now, if at the end of 72 hours they don't want to let you go, they can get you to either switch to voluntary. Remember, I told you, you're probably not even going to know what you signed. Or they just go file what's known as a petition for placement, meaning they want to keep you for much longer, potentially up to 6 months. In fact, Evan and I have a case tomorrow that we're going to litigate for a young man in northern Florida where they want to keep him for 6 months. And we're going to be fighting that case because it's just completely unreasonable. And there's a much better alternative here as well. So if they decide to file to keep us, to keep you, your loved one, there's going to be a hearing within 5 days. And that's when things can potentially go sideways. So just a couple of changes to the Baker Act for 2024. Again, this is not all of them, but this is some ones that really sort of caught my eye and I wanted to share with you. the big one here, the right to communicate. One of the things that the families tell us all the time, you know, my loved one got Baker acted, and I cannot find out any information. Now the statute says that if the facility decides to cut the family off, they better document why they did it, okay, and they better tell the patient. The idea being, we don't want people falling into this sort of black hole, as it were, and then being lost. The other change that really caught my eye was this, where it says law enforcement may take the person who appears to meet criteria. Before it used to say shall. If law enforcement went to the scene and they believed the person met criteria, they had to take the person into custody. Now they may or may not. Again, I have an issue with that because we now have, you know, law enforcement officers having more discretion than ever to make a clinical decision. And I have a problem with that. I don't think that's what should happen. Here in Delray Beach, the Delray Beach Police Department, they have an amazing clinician. She's part of the police department. If the police department had a clinician and that person went with law enforcement to the scene, now we could make a clinical decision, right? And I think that's what needs to happen. But again, I'm just one man sitting in front of a computer trying to help a lot of people. And the last one that I really noticed that came to my attention was the issue of children getting Baker acted. And we see a lot of those. I've seen kids as young as 5 years old getting Baker acted, you know, saying something in a chat room, making a statement to another student, you know, about whether they might harm themselves or harm another child. And the parents wouldn't find out till after the fact that their child was handcuffed and put into the back of a police car and taken to a receiving facility. Now, at least the police are required to tell the parents, you know, where's the child? What's the contact information? Because it's so traumatizing, not just for the child, but for the parents too. And again, this is the criminal courts. I think I talked about that. The punishment code here in Florida: punish first, rehabilitate second. We have our specialty courts, mental health courts, drug courts, veterans courts. You know, really terrific. You know, it's really been a game changer, I think, to get people out of the criminal system and hope they don't come back. I mean, we want to get them treatment, right? That's the goal here. One other quick issue is this going to go on my record? Marchman Act and Baker Acts are confidential filings. But here in Florida, if you get Marchman acted or Baker acted, they're probably going to take away your right to have a firearm, your concealed weapons permit. Unfortunately, there's no way to expunge it, remove it from the court file, but it is confidential, meaning it's not there for the whole world to see. Unlike a criminal case, which is basically an open process. You can go into the courthouse, watch criminal cases all day long if you want. Those cases can be expunged, but not Marchman Acts and guardianships. Just a couple of challenges that we see. You know, we're dealing with family dynamics. We're dealing with an emotional situation. And sometimes it's tough to get everybody in the family on the same page. We deal with spouses that are divorced and they come together to try and save a child. But if you cannot get both parents on the same page and one parent wants to do this and one parent wants to do that, then it's just a no-go for us. I just can't be representing the mother trying to put their adult child into treatment and the father's, you know, saying, no, that's not the right thing to do. It just doesn't work. So we really have to be, you know, rowing in the same direction. And look, we appreciate the fact that this is a serious commitment of time, of energy, and money. And we know by the time the parents have gotten to us, they've probably exhausted their money and they're running out of time and they're running out of energy. So these are some of the things that we deal with. This is my contact information, and I wanted to share this with you because I'd be more than happy to share this slideshow with you. If you want a copy of it, and just shoot me an email. So that's me, Mark, with a K, at AstorSimovicLaw.com. ASTOR, which is my last name, Simovich, which is my wife's last name, SIMOVITCH law.com. Or you can find us on the web. There's the Mental Health Addiction Law Firm.com. There's the Baker Act Attorneys.com. And all over social media: Facebook, LinkedIn, Twitter, Instagram. And that's our phone number, 561-419-6095. And thank you for tuning in. I know by the end of the day, everybody's exhausted. I know I am, but just having the opportunity to share this with you, I'm very, very grateful. Thank you. Let me see if anybody has any questions here. Let me just see if I can stop the screen share. And there we have it. So anyway, if there's anybody who has any questions, that would be great. I'll be happy to answer them. I wonder if I can share my email with everybody. I don't know if I can. Like I told you, I'm technologically challenged. Oh, here we go. I'm going to put my email in the chat here. So if anybody wants the slideshow, I'd be happy to share it with you. And if anybody has any other ideas, my wife was texting me saying, you could do a whole slideshow just talking about, just the Marchman Act or just guardianship or just Baker. I'd be happy to do it. Yeah, somebody put in a Baker Act is basically a scam. I don't disagree with you. And that's a good point. And here, my wife has texted me. Somebody has a question. Let's figure out how to do this. Yes, my email is on the Florida Bar website. I think the photo of me there has a lot more hair. Sorry about that. I got old. Yeah, so if anybody has questions and for some reason I don't get to them, shoot me an email. I'll be happy to answer them. Audra, does anybody else have any questions that I missed? Audra's my wife, by the way. So it looks like, can Baker Acts happen on oral testimony? Yeah, that's a really good question. Okay, so, I put out a video, and actually I did a little bit about, talked a little bit about this today. I always tell people it only takes two things to get you Baker Acted: a finger and someone appointed. That's it. And I'm going to give you an example of that. I had a case where I represented an adult woman. I think she was in her 30s. She was down here in Florida, and her mother was up in Minnesota. And the mother and the daughter had, a little bit of a combustible relationship. And in the middle of the phone conversation, the daughter said to the mother, "Listen, what do you want from me? Should I take a knife? Shall I cut my throat? Will it make you happy?" Well, the mother promptly hung up. She called down to Florida, and she told the police that her daughter was on the other end of the phone, on the other end of the line, and she was threatening to cut her throat with a knife. And the police went over there, and they, I'm going to answer that question again, Cynthia. Thank you. And the police went over there and said, "Did you tell your mother you were going to cut your throat?" And she said, "Yeah, I was having an argument with my mother." And I said, "What do you want from me? Should I take a knife, cut my throat, and make you happy?" And they said, "Let's go." And they Baker Acted her, and they placed her in handcuffs, hands behind her back, as if she had committed a crime, and they took her away. And of course, one of the big rubs with the Baker Act here in Florida is if you get Baker Acted, nobody knows you're there. This is not like a criminal case where you have to be, you have to come before a judge within 24 hours if you can't bond out of the county jail. If you get Baker Acted, nobody knows you're there. The facilities don't report to anybody. They don't have to tell anybody you're there, and they are judge, juror, and executioner. And the ones that abuse the Baker Act the most will take advantage the most. And if you have health insurance, they will fight like hell to keep you, because this is how they make money. And so, on that particular case, I had to, we filed an emergency petition with the court, and we said, "Look, Judge, this is ridiculous." And the court said, "Yeah, you're right." And we got him out. But it took something as benign as a phone call and the mother calling down here with no corroborating evidence to get this poor person Baker Acted. So it's really easy. So yeah, an oral statement will get it done. Cynthia says, with a guardianship, can you force someone with mental illness to take medication? Yes. That is a really good question, and we get that a lot. One of the things that we see a ton of is people who are med non-compliant, and they take their meds, they feel better, so they stop taking them, or they take their meds, they complain they don't feel so good, they stop taking them, they start using other things like recreational drugs. And while I'm not a clinician, one of the things I have noticed with medication is sometimes it works for a little bit and then stops working. Sometimes you have to change the meds to get the right meds. And so, there's a real science to this stuff. And so, yeah, I mean, if somebody's med non-compliant and they're either self-medicating with a recreational drug like marijuana, or worse, they're simply not taking their meds, then yeah, I mean, we will ask a court for a court order to have them taken to a hospital and forcibly medicated with an injection, because you simply cannot have somebody running around like this. Now, I will tell you, we need a court order for that. But if you get Baker Acted here in Florida, and nobody knows you're there, they will forcibly medicate you. They will hold you down and they will stick a very large needle in your backside and they will medicate you. And I've seen cases where the person didn't need to be medicated and they injected them anyway because they want to keep everybody nice and calm. So we will go get a court order for that. You get Baker Acted, and there will be no court order for the most part. Yeah, I think okay. This happened to one of my clients with information. No, and I don't know who this LinkedIn user is, but you make a good point about them being voluntary. Yeah, I mean, the statute says you're supposed to give informed consent, meaning if I decide to go voluntary, I understand the consequences of doing so, because I'm basically incarcerated by the state of Florida without any due process. So I better know what I'm signing. But because nobody knows you're there, and here's the icing on the cake, you can't sue for any of this. These facilities are immune. They're agents of the state, and as such, they enjoy the privilege of immunity. You can't sue them for coercing you to sign a voluntary admission agreement and holding you way longer than they should have done. Now, God forbid you get injured, and we had a case where we had a young lady who was raped in a facility. That's a different story because they have a duty to keep you safe. That we were able to sue for. But absent some type of documented physical injury, if they coerce you to sign a voluntary admission agreement, keep you longer than they should have done, cut you off from your family, forcibly medicate you, as a general rule, you can't sue them, so they don't care. You could file a complaint with the health department, but good luck with that. Yeah, I think somebody was asking me, yes, I think the big issue here, there's no first appearance. So here in Florida, if you get arrested for a criminal offense and you can't post bond, in other words, you can't pay the jail, the documented scheduled bond, you get to see a judge within 24 hours to address two things. Number one, the legality of your arrest, right? Was there probable cause to even arrest you? And two, what's a reasonable bond? What are reasonable conditions upon which we can release you? Because we don't want to house people. First of all, it costs a boatload of money to house people in the county jail. And two, you're presumed innocent. So why should you be locked up? Right? Let the state go prove their case, then they can lock you up. But we don't have that in the civil system. Think about this. If you've been alleged to have committed a crime, you get due process as a matter of law within 24 hours, and the court will appoint a lawyer for you. You get Baker Acted. You've done nothing wrong. Maybe you have some type of mental health issue going on, but you've done nothing wrong. You're not a criminal. And you don't get any due process. Not unless you call somebody like me who drags this facility into court. Or if they file a petition for placement, which for the most part means it's too late because now they're planning to keep you and get a court order to do so. So it's completely draconian and it's broken. And, I actually did a local TV interview right after they made these changes. And I said they missed this thing by a New York mile. There was one thing, if they could have fixed one thing, this is it. This would have probably halted the abuse right there and then, or at least forced the facilities to prove that you met criteria. And you can tell I'm upset about this because it's become a passion for me. And as I told you, I had a family member Baker Acted, and it was 2 days after I lost my dad. So yeah, and I was there with the cops, the EMTs, and all of the craziness that happens when somebody gets Baker Acted. So when I tell you I know Baker Act, I know Baker Act. And I've also been there with close to 500 other families, over the years who've had loved ones Baker acted. So, yeah, the Baker Act's a problem, but you got to understand how these things all work together, because we've had clients that were filed a guardianship, we filed a Marchman Act, and in the middle of it, somebody got Baker acted. Well, if you don't understand how these three laws all work together, well, then I it's a problem, right? Which is why I don't believe in just doing the Marchman Act or just guardianship or just Baker Act. We work in all three of these systems because they all work together. And if you understand how they work together, then you can get a great result and you can save somebody. If you don't, then things can go south quickly. Anyway, I appreciate. Okay, Jane, I think I went over those changes. But if you send me an email, mark@astrosimoviclaw.com, I'll put it in here. I'll send you the slideshow, and it does outline some of the changes. Not all of them, because here's the Baker Act statute. I'll show it to you. It's 138 pages long. I just printed out the new changes. I've been going through it. There's a lot to it. So I've highlighted the ones I think are going to make the biggest difference. But if I'll put my email here again. If you send me an email, I'll send you the slideshow. I'll be happy to. So it's been a long day, and I have a hearing tomorrow. I appreciate everybody tuning in. Thank you for doing that. I'm very grateful. And shoot me. Yes, it's easy to abuse. I'm on LinkedIn. Shoot me a message through LinkedIn if you have any more ideas about what you'd like me to do, and I'd be happy to do it. Thank you. Thank you for tuning in. I'm very grateful.